Morning, everyone. This is Shawn Farrell. I can see that most people have checked in to the seminar. I see a few more jumping on right now. I hope everyone is having a good day and is staying safe in this new environment that we find ourselves. And that's really, one of the reasons why I was excited to do this seminar is that we're kind of in a new environment, something that we've really never seen before in this magnitude anyway. And it really does raise some interesting legal questions that we're all going to have to, in one way or another, face. So that's the purpose of the webinar. There is an ability to ask questions. So for those who are who can find that chat section, the question section, you can feel free to send me questions while I'm doing the seminar. I'll also try to leave a little time at the end of the seminar for any follow-up questions that I might not see pop up on my screen. In all candor, I'm getting more and more acclimated to webinars, but I'm used to speaking in front of people, not necessarily on a blank screen where I can't see you. I actually put on a jacket today. I was excited when I woke up. It's one of the first days in about 5 weeks that I was able to do that. So I know a lot of the people that are attending this webinar are clients of the firm, some are not. So a little bit about me. I'm one of the owners of this firm, Cohen Seglias. We are a specialty construction law firm. We represent contractors and general contractors, subcontractors, but we stay mainly in the space of construction. I've been doing this for about 25 years. I'm licensed in 3 states, New York, Pennsylvania, New Jersey. So when I'm talking about the enforceability of these, I'm talking in the spectrum of federal law. I'm licensed in all those 3 states and federal courts as well, and those states in particular. If anybody's joining us from California, I think a lot of this is transferable. These principles of law don't really change significantly between state to state, but there might be certain state distinctions that you want to, confirm with your own counsel at a later time. One of the things I like to do is educate people on these types of clauses in this contract and what they mean and how to protect yourself to stay out of litigation. And that's the purpose of today, by the way, is to stay out of litigation. Believe it or not, you're hearing that from a lawyer. I want you guys to be armed with what your contract says, or if it doesn't say the terms and conditions that we're going to go over today, what you can do anyway to protect yourself. I feel a little bit like that Farmers Insurance commercial where you see the tagline is, "We know a lot because we've seen a lot." And that's kind of how I feel about specializing in this practice of law for the last 25 years. I've seen a lot, and I think I can help you guys understand the risks. So moving on to the next slide, if I can manage that. Yep, there I am. That's me on better days with a haircut and a suit on. I'm sure we all relish the opportunity to get back to those days. So let's start with what is a force majeure clause? What does it mean? Because that's really the heart of your protection in this current coronavirus environment. Technically, it goes back to ancient times, Roman times, French times. It's a French word. It means superior force. But really what it's trying to do, it's recognizing that your obligation to perform any contractual obligation is limited by possibility, meaning you can't contract with somebody to do the impossible and then sue them for breach. If you had a contract to say, you're going to build me a rocket ship to get to Mars, and let's say this was in the 1800s when you didn't even have a rocket ship, you couldn't hold someone responsible for any damages that would fall out of that, because in that time period, it was impossible to do that. So that's the general historical explanation for what force majeure clause is. There has to be a change of occurrence, an unavoidable accident or incident, and that must be an extraordinary event. So in today's culture and in today's world, these are the elements, these 4 bullet points are the elements that you would have to prove if you went to court. And it's very similar. It hasn't changed very much. It's an event that's beyond the control of the contractor. That doesn't mean that you can't control your subcontractor or your sub-subcontractor, that they're doing things that you could have never imagined. Trust me, I have a lot of those stories where a subcontractor or a sub-subcontractor or vendor does things that we could have never anticipated. But that's not force majeure. That's not what it means. It's an event that you can't anticipate. A lot of contracts, even public contracts, and I'm thinking of New York City in particular, they'll have in their standard form New York City contract a clause that says, expect to be suspended or delayed. Expect that you're going to have to come back to the same area multiple times. If your contract is saying those types of things, if that's the language of the contract, it's not unanticipated. To the contrary, you guys are dealing with that, right? So if you have a contract, maybe an EPC contract, and you're dealing with giving a price and it's only 30% designed, guess what? It's going to be, you better be a lot more careful about the structure and the words that you use in a force majeure clause, because a lot of things are going to be anticipated for the drawings, right? So you're responsible for what's on the drawings or what can be anticipated from them. If you're giving a price, especially if you give a lump sum price with 30% complete drawings, that's not what we're talking about either. The event must be unavoidable, and the parties of the contract can't be part of the cause of the event. So let me give you sort of a real world scenario, real case that I dealt with on force majeure. It was a few years ago. It was in the city of Philadelphia, and they were putting up high-end condominiums, and they were going to use precast walls on the outside of the structure. The general contractor hired a sub. The sub was going to use a precast manufacturer in the middle of the country. Well, despite it being a concrete plant in the middle of the country, it burned down during construction. We went to court. A lot of people were arguing this is a force majeure event. No one could have foreseen it. It was unanticipated. It was unavoidable. There was no, allegations that anybody lit the plant on fire in the middle of the country. Court did not find that the force majeure clause was a release from liability to the general contractor under those circumstances, because he was responsible for his subcontractors, because they chose the precast manufacturer. So they were part of the decision-making process. They could have went to a lot of precast manufacturers. They chose this one. And this one had this event, which was certainly unforeseeable, but not unavoidable, according to the court. So that's an example where, knowing now what doesn't apply, if we have an event that we think is going to occur under a force majeure clause, we've got to stay away from that. We've got to frame, language that shies away from that and kind of shows that it is unavoidable. So what are some of the things that courts generally recognize to be within a force majeure clause? Wars, riots, earthquake, flood, and maybe even coronavirus. If we can put that into the contract, it can be whatever you want it to be. You can negotiate the terms of a force majeure clause, right? So you can put any governmental approval that you need to be a force majeure event, even that the owner will be able to get permits for the start of construction. If that's what you want, and that's what you agree upon with the other side as to an event that's outside your control that would fall within a force majeure clause, you can have that in your contract. So let's think about, all right, if we have this definition of force majeure, these events are force majeure, and one of them happens, what are some of the remedies that we can get if that occurs, one of these events? Well, you can get extra time, extra money for not only labor, but material and equipment, and for home office overhead. These are the things that you've got to be thinking about in this current environment when you're sitting right now and you're on your jobs in New Jersey are in full force, and some jobs in PA aren't if you're, unless you're an essential business, but utilities are in that, and there's hospitals and There's a lot of things that are in that. What is happening right now? Are you getting the efficiency and the productivity that you would have expected on these jobs? If not, is it related to this coronavirus? Another thing to think about as far as a remedy is, if this continues on, and luckily we see in the news that there's sort of a break in the amount of people that are getting the coronavirus right now. But let's say that is tied to the fact that, we're all sheltered at home. And, if it reoccurs when we go back to work, or, things get worse, and knock on wood, let's hope not. But if they do, even if you get additional time, at what point can you say enough's enough? I don't want to go back to this job. It's been too long and I need to move on with other things. So these are all the types of remedies that you've got to be thinking about when you're negotiating a contract or looking at the contract that you have as to when a suspension might even roll in to a termination. Okay? So with this understanding of what is a force majeure clause, let's look at the other side of the coin. I find it helpful sometimes to look at what it is not. And a force majeure clause is not a mistake by a party. So if you made a mistake at bid or in performance, any expectations or skills that you brought to that, be it schedule, buyout of material, maybe the availability of skilled labor, maybe you're even in a foreign jurisdiction or a different state, and that labor pool isn't what you thought it would be, or there's a extended lead time for delivery of necessary material. All of those things would constitute a mistake of a party and would not be part of a force majeure clause. Because the force majeure clause, in its essence, is saying this event happened and you should not have any harm befall you as a company. There shouldn't be any impact to you because it wasn't in your control. We didn't see it coming and you couldn't have stopped it. The stakes are not that. And the mere presence of a risk or uncertainty certainly isn't reason to say that you've experienced a force majeure clause. And the example I give you is one that you well know, which is if you're entering into a lump sum contract, the cost of the goods or what you think you can get if you're not a union shop, what you think you can get labor for as a wage, that risk is on you. It is not part of force majeure. So it's not a get out of jail card exclusively across the board. There are limitations on its enforceability. So the way I've described this is pretty much an impossibility of performance, right? So it's when some event happens and you cannot possibly perform your contract. And that's what it is. And I think many of you, if we were sitting together, would say, well, isn't impossibility of performance always a defense to performing a contract, despite whether or not there's a term in my contract that speaks to that subject matter? And you'd be absolutely correct. It is. There's a doctrine of impossibility of performance. So why are we concerned about the contract if we have a doctrine that really gets us to the same place? And the answer to that question is judges and juries and the discretion that you're leaving them if you don't have it in your contract. And that is a place you don't want to be. You don't want to be where a judge or a jury who has no knowledge about your business, no idea how to build anything, is going to decide what two parties to the contract meant about force majeure. Because that opens up the door to their subjectivity on the issues. And what a judge will look at to see whether or not you have this as a defense. So let's say an owner or GC is saying, hey, you've got to come out here, you've got to perform. And you're saying, no. There's an impossibility of performance. Well, the judge is going to look at factors like foreseeability. And foreseeability is, could we have imagined this occurrence happening? And maybe your answer is, well, no one would have imagined the coronavirus happening. There's, any number of news articles and and reports on TV daily about how no one saw this coming. But that's not really foreseeability, right? A judge, to give you the alternative sort of analysis, could say, well, people always get sick, right? And if people always get sick, there's always some part of your labor force that's not showing up. So you should have foresaw that there was a possibility that virus, sickness, labor resource. Why isn't that foreseeable? You don't want a judge who's prone to see things in that manner to determine that you could have seen it. You might get a judge that is very pro-union. He might say to a non-union contractor under a foreseeability analysis, well, become a union contractor. They've got a ton of guys sitting on the bench, and you could have pulled any one of them to meet your labor resources. So the fact that your men are concerned about their health and welfare and they don't want to come out onto the job, that's not unforeseeable. You know of unions. You know that they have large workforces typically in larger cities available to work. So become a union contractor, right? You could see where a judge and his proclivities to being pro-union might support that type of analysis, which would leave it open to his discretion to say that it should have been foreseeable for you. And another factor that a judge could look at is severity. Severity meaning, what's the duration of time that's transpired? And let's say we're in a current environment where, we're back to work in May. I hope we all are. Well, if you've been out, we're going on our 5th week right now on this issue. If you haven't been out to a job site for 5 weeks, forget about May. If you get out there right now, what would be the domino effect of you getting back on site? What's the remobilization cost? What's the learning curve? Are the same guys and women coming out to the job to build it? A judge may think of it and say, well, 5 weeks is not that severe. It's not that long of a time. It might look to other jurisdictions to support that analysis, no matter where you are. I can tell you in New York City, for example, getting on a contract that doesn't start for a long period of time after the award is not unusual. I had a contractor on the World Trade Center. There was a 2-year delay to the start of the construction. 2 years. Material prices had increased. Labor had increased. And according to the terms of that standard contract, they had to come back. So you could see where a judge, even in a state like Pennsylvania or in a state like New Jersey or anywhere across the country, might look at that occurrence and say, well, this is not that long of a period of time. But they won't understand the domino effect there, the lead time for equipment, getting the right guys out there, loss of efficiency. That's asking a lot of a judge who's not typically or may not be typically accustomed to construction cases. To digress for a second, the last, I think, 4 trials that I've had, the beginning of the trial, the judge has pulled me aside and said, you know what, Shawn, if this was a personal injury case, I could tell you how much this case is worth down to the nickel. I have no idea what you guys are even talking about or how this is framing out and who's going to win or not. And it was until the end of the trial, until the judge is really understanding the complexity and the coordination that's required on any type of construction job of any material size. So with all that said, you don't want to leave it up to a judge or a jury. And I say a jury because, listen, ultimately, you wouldn't want this to go to a jury to have the contractual defense of, hey, jury, listen, I've got this force majeure clause. It says that if there's an act of God, I don't have the responsibility for the damages of the owner and or the GC. Because they're going to do even a less sophisticated analysis. I don't think that they're going to ping onto the ideas of foreseeability and severity, but ultimately, just naturally, they're going to have to weigh those arguments out and come to a means of deciding that. And that's a very scary place to be. You'd much rather deal with it on the front end of this in a contract. Also, if it's in a contract, you're going to limit the amount of disputes between the parties. If it's clear, unambiguous, and you've articulated it that way, then there might not be litigation at all. What often drives litigation, to be honest with you, is one party can read a clause or a provision of a contract and legitimately believe it says something different than the other party. And then the courts are left with the signed contract. They're going to make some type of objective analysis over what it really means. And what a court decides, on occasion, is different than what either party really decided. But the words in the page have to have meaning, and the court, if the two parties don't agree as to the meaning, will determine that meaning. But if it's clear and both parties understand what it says, then you can stay out of litigation, stay out of a dispute, not worry about whether or not one party feels it is or isn't contained and controlled by your force majeure clause. So for those reasons, you've got to look at it into the contract and hopefully address it. Now, the good news of this is, if it doesn't say anything, you do have a fallback provision of impossibility of performance. So when drafting a clause like this, what are some of the things that you should consider? Well, here's a bullet point of things that whomever is drafting your contracts, be it internal or external, give these bullet points to them. This is something that they have to think about. They have to specify the events that constitute force majeure. And you can pick, as I've said before, anything outside of your control. But be specific. Write it in there so that we don't have to read into it that an act of God includes a pandemic or coronavirus. We already know right now, according to the news reports, that while this may decrease in people coming down with the virus in the summer months, there's a possibility that in the winter months it comes back. So for contracts that you're talking about right now or that you're going to be entering into, absolutely identify coronavirus by name or any like virus, so that you're making it broad to say, listen, if these things are going to hit us, we've got an issue. Or do it with the World Health Organization. Anything that the World Health Organization decides is a potential life risk factor. There's a million ways to structure it. Who's ever writing your contract should be looking at that. The next thing you've got to consider for these clauses is who's allowed to invoke the clause. Just the owner? Just the GC? A subcontractor? Maybe you want to make it broadly to say anybody who's impacted by it. But you can certainly structure that clause to say it's not even up for debate. If I'm a subcontractor and I'm impacted by coronavirus, I get the following. Go back to the remedy slide that we just looked at, and then we can say that those are some of the remedies that I get. You can say without the necessity for the issuance of a change order, if a force majeure event happens, I get these remedies. Simple, direct, nice, clear, short sentence. That's all you need. That's what you want. And when you have that, you won't leave it up to the discretion of a judge or anybody else. What else do you have to look at? Which contractual obligations are covered by the clause? What do I mean by that? That kind of falls into the next three, really. Do I get time? Do I get money? Do I get both? You can look at it and talk about the time period for suspension of work. And you can do this at the beginning of a job, like if I don't start the job, how long am I going to hold my prices? Or if I'm in the job and it gets suspended because of coronavirus, how long does that suspension have to go before I can roll it into a termination and say I'm not coming back, right? And then, relief like increased cost, material, and wages. These are the things that we've got to talk about. Now, I want to give you guys an example of what a good clause might look like. So my first example here, and you can take this clause, copy it, paste it into a contract that you're working on, right? So I said at the beginning, one of my goals here on this webinar is to keep you guys out of litigation. The best way to do that is for me to provide you with examples of language that you can start to use right now in your contracts, right? So here's one, and this one is tied to actual cost. Okay, so it says, if there's an increase in the actual cost of labor and material charged to the contractor because of an event listed above as force majeure. You can alternatively put this next phrase in excess of 5% to the making of this contract. The price set forth in the agreement shall be increased. All these terms are negotiable. You could say 10%, you could say 15%. Have a discussion with the person that you're dealing with and see if you can get to a meeting of the minds. Now, what I want to let you know is even if you had a clause like this in the contract, that's just one piece of the puzzle if you tie it to cost. If tied to cost, you're eventually going to have to prove that out, right? So if you tie it to cost, you're going to have to eat your bid estimate, your working papers. Oftentimes, when we get into disputes and I'm dealing with contractors and talking to their estimating department, if it's they might estimate it, but the dispute doesn't happen to the end of the job. It could be 2 years, 3 years from the time they really bid it that we're looking at it, and they can't find all their working papers. If you've got clauses like this where you're going to say, hey, listen, if this unknown event happens and my cost increases from how I bid the job, you're going to owe me additional money. Well, then at that time, you're going to have to show the owner, the general contractor, what the cost was. Hold on to the proposals that you get at bid time when you're frantically running around trying to get vendors and subcontractors to give you numbers. Hold on to those numbers. Hold on to your notes. That way you can go back to the party who you have the contract with, and you can show what supported the price that you provided to them. And that way you're going to stay out of litigation, right? Because that way you're going to be able to show them what the cost is, and that you're not trying to just recapture a bad number, or that you're trying to take advantage of a situation and make more money than you ever really intended to. So let's look at another example. So this example number 2 is tied specifically to the coronavirus, right? It says the contract price for this construction project has been calculated based on current prices for the component building materials. Now, if you're a site contractor, it might not be building materials, but you got to adjust this for the trade that you're in. However, the market for building materials may become volatile, and sudden price increases could occur as a result of the coronavirus outbreak. So this is specific to the coronavirus outbreak. That's what we're saying in this clause, if it happens. Now, again, that's a little bit more narrow than the other clause, example number 1, which said any event in force majeure. This one's dealing directly with coronavirus. Part of negotiation is taking a little bit of what you can get to reduce the risk. If you were dealing with someone, they didn't want to give you a broader, which would be example number 1, any event in force majeure is that increases the cost, you get it. Maybe you narrow it down to coronavirus or whatever else you're directly concerned about. Now, again, if you go down toward, I won't read this whole thing, but this is also, if you go down maybe to the 4th, 5th line, it says the owner agrees to pay costs in excess of the original bid costs incurred by the contractor. Again, if this is in your contract, you've got it tied to the original bid. You got to keep a copy of how you got to those numbers, right? Otherwise, it's going to lead to a dispute, despite the fact that you've got language in here that entitles you to some form of compensation for money and time. So those are some good examples of contract language that you can take and you can put into your contracts and hopefully protect yourselves in a better way. So let me address what some of you might be thinking right now. Well, I've got contracts. I've been signing them and performing them, and they may not have any type of force majeure clause in them, and they probably, most likely, don't reference the coronavirus. What happens then? Well, listen, you got to have your contract reviewed by an expert, and I mean a lawyer. And this is not a shameless plug for lawyers to get work. But right now, there's an old adage, you save money for a rainy day. It's raining. I would look at, 3 major projects. I'd advise, what are your biggest 3 jobs that you're running, and have someone look at that contract language, right? And determine whether or not it's a force majeure clause. Determine whether or not it encompasses something like a pandemic or specifically the coronavirus. Or if it doesn't have anything in there, then you've got to talk to your legal expert about how do we craft communications regarding this project. I'm talking about letters, emails, phone calls, meeting minutes. How are we talking about that? And you're going to craft that language around one of two things. If you've got the clause, you're gonna fall on the contract. Why? Because you don't want to give them the argument that the contract doesn't address this issue. And again, now you're at the discretion of the court. If it's clear, your legal counsel is telling you that it's not in your contract and that you can't rely upon the contract for avoidance of liability that might befall here or additional costs, then you're going to gear everything towards impossibility of performance and that paradigm. That's how you're going to frame your emails, your meeting minutes. You want to make sure that they're recorded correctly. You want to do all of those things because that contemporaneous documentation will drive the entire defense for you, okay? Even if you have a contract, by the way, it's very important to get the language correct because here's something that no lawyer likes to tell their clients, but it's absolutely true. Any contract can be amended. Any contract can be amended. You're thinking, nope, not mine. Mine has what my lawyer described as an integration clause, which says that the contract documents, and it's usually found in Article 1 of most form contracts, the contract documents consist of these things, nothing else. Well, that is true. That is an integration clause. And what that prevents is the introduction of any statement or writing that preceded the signing of the contract, but not following the signing of the contract. Your actions can always manifest a sense. That's a fancy way of saying your words can always change what the terms of the contract say. It's better not to rely upon your actions because two people can see an event differently, but your actions can always do that. So you can always change the terms of the contract. It's possible you can waive rights through your conduct. Bit of a digression. To some degree, we're probably all familiar with the partial releases and waiver of liens that we have to sign every month to get payment. They're enforceable in PA, New York, and New Jersey for sure. And it is a concern because when you're getting paid, let's say you did $100,000 worth of work in January, and come February, you want to get paid, but they say, here, sign this waiver. But you know there are additional costs that happened in January, and by signing that partial release, you may be waiving your right for that additional consideration. And that is true. And you may very well waive your right to additional consideration if you sign that document. But you can also show that a party's actions that center around that clear waiver of your rights in the partial release show that it did not mean you waived anything. And I successfully won a few cases on that point, but the one that's coming to mind was in Tennessee on a Veterans Administration hospital that my client was demolishing from 10 floors down to 3rd. Now, why did they want a 3-floor structure and just knock the whole thing down? I don't know. But at any rate, he had signed in a 2-year period probably about 24 of these releases of liens and waivers, and it would have barred his claim entirely, except for in month 1, he had all these pending change orders that they didn't get paid until like month 6. And there were a few occurrences of that where month 2 had pending change orders that didn't get paid till month 10. Month 6, he didn't get paid till the 14th month. And because there was those actions that showed this isn't really a waiver. Because if you're waiving everything month by month by month, you wouldn't have paid any of the change orders. That's where your actions can alter the clear terms of a contract and a partial release of waiver. So the point being that even if you have a force majeure clause, you've got to make sure that if you're being impacted by delay or inefficiency because you're not getting the workforce that you need, that you're out in front of it with these letters and emails and phone calls and meeting minutes and making sure that it is showing that you are entitled to additional money or time or both. Now, the last point, if you've got a contract signed with a force majeure clause or not, is the other provisions in your contract are still enforceable. So the big one here is notice. You have to comply with the notice provisions that are in your contract. You can't ignore them. You've got to get out there so that the general contractor or the owner immediately within the terms of your contract, and a lot of them say, 7 days from the first occurrence of an event giving rise to something that you're asking for additional money, you've got to notify somebody. You've got to comply with that. So you got to get out in front of that. So I provided you, and we'll look at it in the next slide, with a notice to a general contractor. This is geared towards a subcontractor, but you can take this and certainly alter it if you're a general contractor to an owner, a potential delay. So the first, sentence starts off in a very non-aggressive way, pursuant to section blank of our subcontract. That'll be the notice provision. Within the notice provision, it'll say within 7 days of the first occurrence, give me notice of anything that might increase the cost of the work or time to perform. Well, they've asked for it. So there's nothing litigious about this. There's nothing wrong about this. They're asking in their contract that you put them on notice. So send it to them. Put them on notice. I have a potential claim here because of the events that just happened. So if you go down to about the third sentence, says, while subcontractor has not currently experienced any impact, it goes on to say, we might. Why do we want that? Because a notice provision to be enforceable is meant to give the other party the opportunity to mitigate, right? So I had a contractor once who was doing site work on a FedEx project, a large FedEx facility up in Pittston, Pennsylvania. And we hit unexpected rock. I mean, there was no geotechnical report or borings that would show the amount of rock that we hit. And it was about a $1.2 million extra that he was blasting the rock, and their whole defense was noticed. And my guy was laughing, like, how would you not know that I was out there blasting over $1 million more of rock? Everybody knew. And we could quantify it because obviously dynamite or explosives are a highly regulated industry. So we knew exactly what our costs were. We knew exactly what the extra was. But they were saying, notice, you didn't put me on notice. Their entire defense was, and the access road that he was helping do on this site work was coming up to the north side of the building. They made a very specious, not supportable by the facts, thank God, argument that if you gave me notice earlier, I would have made the access road on the south side of the building instead of the north side of the building. And therefore, you caused me prejudice by not putting me on notice. Now, my guy didn't write the letters, didn't send out these kind of notices, is at every meeting they were discussing his circumstances and the additional work that he was doing. And he thought that was notice. But that's not notice, because a contract will say, in writing, provide me with notice. And there was no writing. But luckily, we were able to get around that to say, fall on the sword. We said, listen, we didn't give you notice. But guess what? There was no prejudice, because you couldn't have used the south side. We were able to demonstrate that. And your resolution was just to have my guy keep working. So if we had told you with a crystal ball before the job began that this was going to happen, the end result was the same. You were going to ask this subcontractor just to keep doing the additional work, and therefore you owe him money. So that was a good way around that. But you don't want to be in that situation. You don't want to have to make that argument and hope that you can prove that an access road to the south side wasn't possible and that he wasn't prejudiced. You want to comply with the notice provisions. Take this letter that's in the PowerPoint right now, copy it, modify it, but get it out. I don't see a reason why you can't send it out right now on every job that's potentially affected. It's not saying you are impacted. It's saying you're potentially impacted by it, and there's no reason not to send it out. By the way, I was giving a seminar like this to a group of people one time, and at the end of the seminar, someone started to follow my idea of sending out these notice letters, and he calls me up and he says, listen, the general contractor now thinks I'm litigious, that I'm trying to set him up for a claim. And I said, okay. And this would work as well to an owner as well. I said, just send them a $0 change order. And in that $0 change order, just say, we waive all notice requirements of the contract. And tell them if you signed it, you'll never send them another letter. And of course, you might see the outcome of this being, he never signed that $0 change order. He never really complained that he got letters that were compliant with the notice provisions. Again, if they're asking for it in their contract, give it to them when the occurrence arises. The next slide that you're seeing here is a notice of actual delay. Very similar. What's the real difference? You're going to be more specific. See where those blank orange bullet points are? Now you're going to say, this is what has impacted me. This is how I've been impacted. And you're going to put it right in there, okay? By the way, you might be asking yourself, well, what if you talked about occurrences where I don't have a contract section that talks to things? What if I don't have a contract section that talks to notice? Well, that's fine. That's fine. And if you don't have that, and if you don't have the contract clause that talks specifically to force majeure, just say, I'm putting you on notice anyway. Again, it gets rid of the notice issue of prejudice, and you can modify this to say, we are notifying you of the impossibility of performance, instead of saying we're notifying you of a force majeure, being delayed by coronas or a pandemic, which is a force majeure event, which is what this letter is saying. It says, which is outside of the subcontractor control and constitutes a force majeure event. If your contract doesn't talk about force majeure events, say, okay, I'm notifying you of the impossibility of performance because of events outside of my control. Again, talk to your legal representative, get an understanding of what your rights are in the contract or otherwise, and then gear these letters up appropriately to make sure that you're protecting the company. This form goes on, and it talks about that at this time, it is impossible to notify you of the direct impacts COVID-19 will have on the project's cost and schedule. Now, if you know what they are, say them. If you can estimate them, say, I estimate them to be. But don't delay sending the notice letter out because you want to wait till you can quantify all the impacts. I get you wouldn't want to sign a change order for this event without knowing all the costs, because you're not going to be able to come back to this original occurrence, the pandemic, and say, I want more money, even though you gave me money under change order number 1. But for the notice letter, send it out immediately, of potential or actual, even if you can't quantify it. And quite frankly, if you got suspended from a job because of coronavirus, you don't know what your damages are until someone says it's over, come back to work. You couldn't even possibly quantify all the impacts that you're going to face under that scenario. But that doesn't mean you don't send it out. My next example, because I'm sure we've got some general contractors on the line as well, is a notice to the owner of potential delay. And it's analogous, very similar to the one that we just saw for the subcontractors. And the same will be for actual delay. Get them out. It's no reason not to get them out. If you're impacted, or just take the, if you want to get practical and you don't want to send out, 10 or 20 letters, take the biggest jobs. Take the biggest jobs that have the biggest risk on them in terms of cost to you if the project is delayed, and get the letters out. You've got to do that. So in addition to getting the letters out, how do we supplement the letters? You can get more specific on any one of these letters by taking from the sample list of impact costs and talking about them. I don't know where your pain point is, but I've given you a pretty extensive list here of all the cost impacts that are usually associated with delay. And in essence, this is just another delay that's outside your control. This one happens to just come from an act of God, right? So here they are, and in the next slide, you're going to see really the big ticket ones, right? It's understaffed. Your superintendent, your senior project manager, your project manager. Maybe you hired a senior project guy or a project manager because they've done this specific work on other jobs, and they weren't employees of your company before you knew you were going to get awarded this job. Happens all the time, right? Well, now if this job gets delayed, you might be overpaying that senior project manager because you're going to put them on a much simpler job that you didn't need to pay the highest wage possible for his skill set. So you got to think about these costs. With labor and employment issues driving the cost of it, which are, listen, in a normal bid, it's typically 60-40 split probably between labor and material is probably a rule of thumb, right? So 60% of your cost is probably within this labor component. You've got to get out in front of it, and you can tell them what the monthly cost is for this project manager or superintendent or whoever makes up the team, and whether or not you can mitigate by having them do some other side work. That's a different issue that may reduce the damages, but it doesn't get rid of the damages, and you want to put them on notice immediately of all these events and tell them what the cost here is, okay? Now, you've done all this. You've got contract that's written specifically, says coronavirus, tied to cost. You've got everything in there. You've done everything right. Is that it? Is that all there is to do? Of course not. If it was, I wouldn't have brought it up. Of course there's more to do. Here's what you got to do. You always have a duty to mitigate. What's that mean? That means if somebody else breaches the contract with me, I don't get to resolve it with the most expensive means necessary. So if there's something that you can do, take advantage of some opportunity or circumstances to reduce the impact of the damages, that's what you have to do. Otherwise, they're going to say that you failed to mitigate your damages, and probably won't be a complete defense, but it will be a defense of some of your damages. So what you got to do, one, get early notice out there. I've been saying that. That's what you got to do to protect yourself with mitigation. Bring stakeholders together. Talk about, well, what can we do? That'll be great evidence at the end of this that you've done everything in your power to mitigate the damages, right? To say you're a material supplier. Well, can you store the material, manufacture it, fabricate it, store it, give it to them, give them a bill of sale? Can you do anything along those lines? Having that kind of correspondence out there will show mitigation, will establish you as the white hat, trying to solve a problem, and courts and juries like to back that type of person. Otherwise, we want to probably gear this into some sort of maybe even termination for convenience and talk about, overhead issues that you have and get out there on those. Can you reduce your overhead, and are you articulating them instead of waiting till the time when you're filing a claim and then you're going to say, oh, my home office overhead is blank dollars. You might want to show them on these early notice letters and have a dialogue with them as what the costs are and how you're trying to reduce them to lessen the impact for this event. So that was a lot to digest, I know. I kind of wanted to get through it. If there's any questions, I'm certainly able to answer some of those questions. I'm going to read one question here that I have, which is, how does a force majeure clause affect no damage for delay clause? All right, good question. Let me explain for everyone what a no damage for delay clause is. It is kind of the contractual term that says what the title is. It says no matter what the delay is, who's at fault for the delay, you get nothing. You get no time and you get no money. Some no damage for delay clause will say you get time but not money. That's a no damage for delay clause. Are no damage for delay clauses enforceable? They are. They are very enforceable. At least in the Pennsylvania, New Jersey, and New York, they're enforceable. How does the force majeure clause operate within that environment or the impossibility of performance? It has to work together with it, okay? So it doesn't trump, it doesn't negate the enforceability of a no damage for delay clause. If you have a well-worded no damage for delay clause, then you probably don't have a force majeure clause in your contract, and it's really going to call into question the impossibility of performance. But the saving grace here is that there are exceptions to a no damage for delay clause. So courts, we call it common law, have recognized the one-sidedness of a no damage for delay clause, and they have put in exceptions. There's 4 main exceptions. It's not contemplated by the parties at the time that they contract that there would be any delay. It's an unreasonably long period of time. Again, you can see where, again, you're leaving this subjectivity back up to the court, so it's better to get these clauses out of your contract if you're concerned about it. The third exception to a no damage for delay clause would be fraud or some superior knowledge about the site or the building that they didn't share with you. You know, let's say that they knew, say you're a site contractor and the owner knew that there was contaminated soil and he just didn't tell you about that. When you get out there, all of a sudden, you know, you're not just taking the soil to a normal facility. You've got to have the additional cost for moving hazardous soil. If the owner knew of that, you wouldn't be, and let's say it also caused delay, as one could imagine, you wouldn't be precluded from seeking delay damages because of that superior knowledge. And then the most common use of an exception to the no damage for delay clause is active owner or general contractor interference, or if you're a subcontractor, subcontractor interference. Doesn't matter where you fall in the chain. The guy up from you, if he is preventing you from having access to your work or preventing you from following the schedule that you've laid out that you want to follow, then you can have a situation where it's an exception to the no damage for delay clause. Okay? All right. Let me read another question here. What if I don't tell the owner or GC within the stated notice time, 7 days? So it often happens, an occurrence has already happened. Let's say we're right now in this environment and you're participating in this webinar and you say, well, I haven't sent out any of these notice letters and we're 5 weeks into it now. I guess I missed the boat and better luck next time. I'm educated on that. No, that is not the answer. Again, it goes back to the example I gave you with the FedEx project and prejudice. If you've not given anybody notice, give it to them now. Let's stop it right now. Give it to them now. But in addition, then you're going to frame communications and languages, emails, and meeting minutes around the fact that they're not prejudiced from the fact that you didn't tell them earlier, that the only solution that they were ever going to come up with was to ask you either to wait and be delayed or to do your work in some other inefficient manner that's going to give rise to your damages. So again, when you're dealing with public entities, by the way, contracts are much more strictly construed, and these notice provisions and getting around them in this manner is much more difficult because the courts will assume that there's a prejudice that there is a prejudice to a public entity rather than to a private commercial construction. So certainly on a commercial construction, either way, you're going to follow the same advice. Get the notice out now and argue no prejudice. On a public job, you really got to look at it a little, the language of the contract and the circumstances a little bit more particular. But in general, it's going to be the same game book. You're going to get the notice letter out and you're going to start articulating that there is no prejudice. Okay? Moving on here, let me see. Question: what if the effect of the coronavirus is one of many causes of delay, including my own delay? So that question is saying, okay, let's say there's 5 factors that are causing delay on the job. One of them is the coronavirus. Obviously, you're going to follow all the letters and the notice and everything else. If there's more than one cause of delay, are you responsible for the delay? And the answer is not if they're concurrent, right? So if I have a delay of the job, let's say I'm starting the job and I didn't give sufficient lead time to a crane that I need, and the crane's not going to show up for 3 more weeks. And luckily for me, in that same 3-week period of time, we've been in the coronavirus. They're concurrent to each other, meaning they're happening simultaneously. And when 2 events, one that you're causing and one that you're not causing, but the owner or general contractor is causing are happening at the same time, then you're not responsible for liquidated damages or any other increase in the cost of performance of the work, because even if you weren't late, they still would have been precluded in the same way from progressing the job because of the coronavirus. So just because the coronavirus is one of multiple things of delay doesn't mean that you shouldn't send out these letters, and you shouldn't try to articulate that you're not responsible for delay on the job. You absolutely should. Let me see if I can find any. I think that's it on questions. We're just about to the end, so I'll give another minute or so to see if I have any questions. And in the interim, I want to thank everybody. We had over 90 participants on this call learning about this event. If I didn't get to your question or we had some technical glitch, my email is up on the screen. You can certainly email it to me, and I will get back to you in a more discreet way to answer your question. Free of charge, part of the seminar. We like to protect people, and the best way to do that is with information and knowledge. So I appreciate everyone's participation here today. These are uncharted times, and the best way to, get around or understand our risk is to go back to basics. Let's look at the contract. Let's look at the understanding of the parties, and let's get out a lot of communication around that in a proactive way so that we can, in the spirit of cooperation, get these jobs completed the best we can to being on time and on budget. So with that said, thank you all for your participation. And this is going to conclude our webinar for today.